Today, I am just going to put across some thoughts on the Commercial Codes Act. I just had it as an overview. I am just going to try. The object of the talk would be that I give a small insight as to what the enactment is, that the act by itself is very small, so that it creates an interest in you to learn more about the objects, the provisions, and what it seeks to achieve. The Commercial Codes Act 2015 is a very, very small enactment. It is basically a procedural law. You can find that what it actually sets forth is culling out a portion of the Civil Procedure Code in terms of procedures for civil suits before the civil courts on a particular category of cases known as commercial disputes. So it is kind of an extension of the procedure code which we have for the civil suits. You all know that the common law remedy is before the civil courts. Any person who has to seek for a remedy has to approach a civil court. Specific remedies are covered by special enactments. So what is not provided and what is as a basic right for a person to approach a court, you normally go to the civil court. And these courts cover various aspects of litigations. As a civil lawyers, you would have appreciated that every other facet of a litigation or a facet of law will be part of a civil proceedings before civil court. So this enactment speaks about procedures. Now looking at a small legislative background of this enactment in terms of the facts and figures, you will find that this Commercial Codes Act 2015 was passed by the Parliament and assented by the President and became a law on 30/12/2015. It was gazetted on 1/1/2016, and therefore in terms of the serial number of the enactments of a particular year, it finds a mention in the statute books as Act 4 of 2016. Now post this enactment in 2018, by Act 28 of 2018, there had been one major amendment to the enactment. So this is on the small legislative background which you can find. Now coming to the Act, as I said, it is a very, very small enactment. It has only about 23 sections to be covered. And these 23 sections, it is split into 7 chapters. 23 sections of an Act split into 7 chapters. As you know, any enactment will have an introductory chapter or a preliminary chapter. Likewise, there will be a final concluding chapter which we will find in every act known as a miscellaneous chapter. So as in all cases, this Commercial Codes Act 2015 also has a preliminary chapter, namely chapter 1, and the miscellaneous chapter, namely chapter 7. Invariably in enactments, you will find this preliminary chapter has only 2 sections. This is almost a uniform. Some enactments you may have 3 sections, but invariably 2 sections. One provision, which is normally the section 1 of an enactment, would always speak about the title of the law and the commencement of the act and its application. So section 1, like any other law, as far as Commercial Codes Act 2015 also speaks about the title, the name of the law. Then it speaks about as to its application, either it is territorial or otherwise. Generally, it is what is provided in section 1 is a territorial jurisdiction. So it applies to the whole of India. In some enactments, you may have restrictions. Earlier, you would have seen laws which say that except Jammu and Kashmir. So when 2015 this act came, it also had the words except Jammu and Kashmir. Then in the 2019, when the Jammu and Kashmir Reorganization Act came, amendment was also made by that enactment to this provision, section 1 of this Commercial Codes Act, removing that portion. So today, in terms of section 1, subsection 2, the act applies to the entire country. Then third will be the commencement of the act. Each act will have its own way of putting across the commencement. Now, as far as this enactment is concerned, it says by section 1, subsection 3, that the act shall be deemed to have come into force on 23rd October 2015. You will recall at the first instance I said the act was passed by the parliament and assented by the president and came into force on 31st December 2015, published in the Gazette on 1/1/2016. But by virtue of section 1, subsection 3, it is deemed to have come into force on 23rd October 2015. So every act provides a particular mechanism as to how it commences. There are enactments which says the provisions of the act will come into force as and when a notification is given to the effect by the central government. Therefore, you would have seen in many acts, the act coming into force on different dates. Either a particular chapters are introduced, certain chapters are not notified, certain sections are made applicable, certain sections are not made applicable, and certain sections from a particular date and certain sections from some other date. So this is happening in very many enactments. As far as this act is concerned, it is very categorical. There is a single point commencement which says that deemed to have commenced on 23rd October 2015. So that itself gives an insight why it is made applicable from a prior date than the date on which the act came into force. That is because prior to this enactment, the law was set in motion by virtue of an ordinance which was made by the central government. So ordinance came into place, it became a law immediately, and it was in force, by which time the bill was placed before the parliament and the act came into force. Therefore, to cover up that situation, the act says that it shall be deemed to have come into force on 23rd October 2015, the date on which the ordinance came into force and the law was already in place. So this is on the preliminary. Likewise, as I said, the last chapter, chapter 7, is miscellaneous provisions, in which normally, this is one area as law students or lawyers which we can show some interest, is that for any enactment, you can find out what is this miscellaneous provisions. Invariably, what will be there in the miscellaneous provisions is that at the first instance in every enactment, you can find a provision with respect to rule-making power of the executive. So that is known as the subordinate legislation. So every act puts in place certain provisions. Now, for the purpose of having these provisions applicable and made use of, there may be a requirement as to procedurals which has to be put in place, which is normally we find in the rules. So therefore, any enactment will provide a rule-making power. So likewise, this act also provides for a rule-making power in chapter 7, which is the miscellaneous chapter. Then invariably all acts will have instances where there is an overriding effect. Certain enactments may say that notwithstanding anything which is there in force as on date, this law will prevail. So there will be some overriding effect to certain laws which had already been there. Or it may be a kind of clarification saying that certain laws will be made applicable, certain laws are not made applicable. So this is also a general provision which you will find in many statutes. So therefore, this act also has a provision under the chapter miscellaneous as to the overriding effect. Then you will have provisions as regarding power to remove difficulties, which is a power given to the executive where they bring about certain notifications or clarificatory orders to remove difficulties in the enforcement. Then you will normally have a provision which is called repeals and savings. So if there had been any other prior enactment on the same lines, the enactment would provide for a repealing of that. Likewise, if there had been some proceedings under the prior enactment, if there is a requirement of saving of such proceedings, that will be provided. So any law will always have a repeals and savings. So as in this case, as I have told you earlier, the law came into force by way of an ordinance which was put in place. So therefore, by a repealing provision, it would say that the ordinance stands repealed and the act comes into force. Likewise, if any action which was taken pursuant to ordinance, the saving provisions enables for that. So this is as regarding two chapters which are general in nature. Therefore, I took it out. Then I will just explain to you as to what actually is the insight into the enactment, what actually is the overview of the enactment. It falls under 4 different categories. One would be the very constitution of these commercial codes. The object of the enactment is that to put in place certain mechanism as to the constitution of these courts which are required for implementing this enactment. As I said, being a procedural law, the establishment of courts is spoken. So that will be one area. So the Act seeks to have a particular hierarchy of courts for the purpose of commercial dispute. Then second one is what kind of suits need to be tried under this enactment. As we find from the title of the law itself, it says that Commercial Courts Act. So essentially, the other area which the law seeks to address is what is the nature of suits. So that they have said it is a suit of a commercial dispute. So therefore, the Act gives an insight as to what can fall within the purview of a commercial dispute. Then it also speaks about a specified value. So on basis of a particular value, the suit should be classified. So two things would be required. One is commercial dispute and specified value. So this is on the second limb of what is the object which seeks to achieve. Then third limb of is that on the technicalities, whenever an act comes into place, does it provide for a specific jurisdiction or does it restrict a jurisdiction? Does it bar a jurisdiction? So all these things are very many facets of special laws which cover subjects. Whenever you find a special law, you can make a small search and find out whether this law seeks to bar jurisdiction of any other law. Likewise, you can also try to find out whether this law seeks to create a jurisdiction. You can take the case of a DRT Act, the RDB Act. That enactment is again a procedural law which created tribunals for the purpose of adjudicating disputes of banks and financial institutions. Therefore, that law provided for the establishment of those tribunals. When it provided for the establishment of tribunals, it also provided that there will be a bar of jurisdiction of civil courts. So therefore, the third area which we can look at is that as to the manner in which the jurisdiction is sought to be vested and the manner in which the jurisdiction, if at all, is being restricted. Now, again, on this jurisdiction, you can look at pecuniary as well as territorial jurisdiction. This is on the third aspect which you can find in this Commercial Courts Act. Then the fourth aspect which you can look at is that on the procedural aspect, as I said, CPC is the guiding law in terms of procedural aspect for civil suits. Now, there is a deviation from that CPC by bringing about a new law for a particular new area. So therefore, how the Act seeks to deal with that procedural aspect. Now, what this enactment does is that it makes amendments to the Civil Procedure Code as may be made applicable to the proceedings under the Commercial Courts Act. So that is the fourth area of it. Now, as I said at the initial stage, the enactment is containing 23 sections. Then I said it has 7 chapters. Now, interestingly, the further addition to that would be it has one schedule and there is one appendix. Appendix is normally the format which an act seeks to provide. So other than that, what is this schedule? This act as a schedule. Effectively, what the schedule is as far as Commercial Courts Act is concerned, it actually sets out what are all the amendments which this enactment brings as far as the provisions of CPC. So therefore, in the schedule to this act, the amended CPC provision as applicable to the Commercial Courts Act is being brought in. So this is a kind of overview which I am trying to put it across to you. As I said, 4 different divisions. One is the constitution of this commercial courts or commercial division, commercial appellate division being one of the main objects of the enactment. So what the law speaks about those things is one area which we can look at it. The second one is that the jurisdiction, either it vests or it removes, whatever it is, or there is a bar of jurisdiction. So this is on the second aspect of it. And then thirdly, I said about the provisions, amendments which have been made to the Civil Procedure Code and other areas which the Act seeks to address. So on this broad outline, I am trying to give a small insight to you so that you get interested on it and you can try to find out for yourself what the Act seeks to put it across to us. Now, coming to the first area, which I said, the Constitution. This is provided under Chapter 2. Chapter 2 of the enactment, which speaks about Constitution of Commercial Courts, Commercial Divisions, and Commercial Appellate Divisions. Under this chapter, there are sections 3 to 11, which is of importance. So sections 3 to 11 constitute Chapter 2, which is on the constitution of the commercial courts. Now, what is the hierarchy which it has provided for? Now, in terms of the original law which came in 2015 and the amendment which came in 2018, there is a difference which has been brought about in the hierarchy. In terms of the original law, the law provided that there will be a commercial court as to matters which can be dealt with by that court, which is of the commercial value, which is of the commercial dispute with a specified value. Then it provided commercial division before the High Court. Then it provided commercial appellate division. So in terms of the original law, the hierarchy was that there will be commercial courts, there will be commercial division in High Court, and one commercial appellate division. But by virtue of 2018 amendment, there is a change brought about. What is the change is that they have introduced a commercial appellate court. This is primarily because of the difference in the specified value. As I take you to that provision, I'll be able to explain that. So for the present, you will only take it that in terms of the law as it prevails today, the hierarchy which has been set forth is that there would be a commercial court and a commercial appellate court. This commercial court is provided, the constitution of this commercial court is provided in section 3, and the constitution of commercial appellate court is provided in section 3 capital A, because it came by an amendment in 2018. Then constitution of commercial division of High Court is in section 4. Then constitution of commercial appellate division is in section 5. So these are all the hierarchies which are prevailing, and this is in terms of the sections which I have said. I will try to just take you through by way of a small presentation as to how this is today there. See, this is how in the High Court, the hierarchy is such that on the left-hand side you will find a commercial court established at the district level headed by district judge. So as against this, the appellate provisional will be to the commercial appellate division of the High Court. Now the other limb of it is the commercial division, which is part of the original civil jurisdiction of the High Courts. As against this, and again the appeal will go to the commercial appellate division of the High Court. So this is one hierarchy. The other area which you can look at is, this is the other area. As I said, commercial court. Now if this commercial court is established below the level of a district judge, then an appeal will be to the commercial appellate court established at the district judge level. Now, if this commercial court is established at the district judge level, as we saw in the earlier slide, it will go to the commercial appellate division at the High Court. So this is on the constitution in terms of the enactment, in terms of the provisions which we saw, and the hierarchy which has been set forth. So apart from this, section 6 speaks about the jurisdiction which is vested on commercial court. Section 7 speaks about jurisdiction of commercial divisions of High Court. At the first instance, as I said, it is constitution. At the second instance, it is jurisdiction which is being vested. Now, when I say about this, there are certain small niceties which will be of some importance as law students. One is that section 3, if you have the book in your hand, you can just see that section 3 speaks about constitution of commercial courts. Now, section 3A, which came into place, in fact speaks about, I will try to bring it on the screen, the particular wordings also you can find for yourself. It actually uses a word designation. Please see section 3 speaks about constitution. Similarly, section 4, section 5 speaks about constitution, whereas section 3A speaks about designation. So at the district judge level, they seek to have a designation. I think you will be able to see it in the screen now. Section 3, Constitution of Commercial Court. Now, there are so many other things in the provision. I am not troubling you reading through those lines and trying to explain, because as lawyers, you would always have a better understanding when you read for yourself as to what the provision says, how the Constitution, when it has to be constituted, what is the role of the state government and what is the role of the High Court. So all those things are provided therein. We need not strain ourselves much on it. It is only on the designation. Why I said is that this was very unique word. When all other provisions said constitution, it speaks about designation. So which effectively means that at a district level, you already have a district courts. So what is required in terms of section 3A is that designate the same district judge as a commercial appellate court. Whereas in other cases, they would require that it has to be constituted by a notification to be given in consultation with the Chief Justice of the High Court by the state government. So in cases of commercial division of High Court, that administrative power is in fact vested with the Chief Justice of the High Court. He is having the power to constitute a commercial division at the High Court consisting of a single judge for the purpose of exercising the jurisdiction. Likewise, in a constitution of the commercial appellate division, the Chief Justice of the Honorable High Court will have the same power to constitute commercial appellate division having one or more benches, which apparently will be a division bench headed mechanism. Then, as I said, 6 and 7 speaks about jurisdiction vesting. Then, having seen this, now within this chapter, one important provision which you can find is that section 8. It effectively says that there will be a bar against revision application or petition against interlocutory order. As a practitioners before civil courts, we are aware that in cases where interim applications are being dealt with by a civil court and orders are passed, you will always look into the provisions of CPC to find whether such orders on interim applications fall within the category of appealable orders, which is there under section 104 of CPC. So if an order which is on an interlocutory application is an appealable order, you have a remedy of an appeal. If it is not so, then you will look that is there any remedy which is available. Suppose an order in an IA is causing you serious prejudice, is likely to affect the rights of the parties. Then you will look at is there any remedy. And that remedy is provided under the CPC by way of section 115, which is called a revisional jurisdiction of the High Court. So therefore, you take that order on challenge before the High Court by way of a CRP by invoking section 115. Now, apart from this, other than invoking the section 115, suppose section 115 also bars certain orders under the IA being questioned before the High Court. In those cases, we invoke Article 227 to seek a remedy against those interim orders. Now, these are all which are provided in the Civil Procedure Code and which is made applicable to all the civil suits. Now, what this enactment does is that it specifically bars against revision application or petition against an interlocutory order. So it says nothing, notwithstanding anything contained in any other law for the time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provisions of section 13 shall be made in an appeal. So effectively what it says is that there shall be a bar of challenging the orders under interlocutory stage, but it provides a remedy in a manner of providing the same relief in an appeal. They say subject to the provisions of section 13. Section 13 speaks about appeals in commercial courts. Now, in that appeal, which you challenge on the final judgment and decree, this can also be part as regarding the order which was passed in an interlocutory application. So it gives a mechanism by which there cannot be any revision or appeal against interlocutory order, but all those issues can be raised in your regular appeal, which you seek to make it in while filing an appeal under section 13. So this is one provision. Then section 9, in fact, was there as regarding which has been subsequently omitted in the 2018 Act. Then section 10 speaks about jurisdiction in respect of arbitration matters. This is again a vesting of jurisdiction on the commercial courts in respect of matters which are part of the arbitration matter. So effectively, this section says all arbitration matters, those will be a part of the commercial courts. Then in section 11, there is a provision which speaks about bar of jurisdiction of commercial courts and commercial divisions. Now it says, notwithstanding anything contained in this act, this is more important. Whenever there is a non-obstante clause, what we are normally used is that notwithstanding anything contained in any other law in force, this is a non-obstante provision which says there will be a bar. Suppose an enactment says that there will be a bar of a civil court to entertain. Take the case of rent control disputes, take the case of, as I said, DRT, the banking disputes, or take the case of insolvency disputes, which is under the Insolvency and Bankruptcy Code. So any law which provides a special mechanism, would normally provide a bar of a civil code. So they don't want the civil courts also to enter into it. So in those provisions which provide for a bar of jurisdiction of civil code, the non-obstante clause will be saying, notwithstanding anything contained in any other law in force. Now, whereas this section 10, it says notwithstanding anything contained in this act. So therefore, a jurisdiction which is vested on commercial courts and commercial divisions in terms of this act. So notwithstanding anything which is provided there, the section further says, a commercial court or a commercial division shall not entertain or decide any suit or application or proceedings relating to any commercial dispute in respect of which jurisdiction of a civil court is either expressly or impliedly barred under any other law for the time being in force. So you find two non-obstante clauses operating. One, it says, notwithstanding anything contained in this act. The last portion says, any other law for the time being in force. What actually this means? This is in a context for a small explanation. What you can see is that for a moment, forget there is no Commercial Courts Act in force. Under the Civil Procedure Code, you are entitled to file a civil suit for any civil cause. Now, under special enactment, there is a bar of a civil court's jurisdiction in entertaining. I will get you to the same example of a banking dispute. In cases of recovery of dues by the banks, they have a remedy under the DRTs, before the DRTs under the RDB Act. Now that Act says any issue which the DRT is entitled to decide under section 17, where a jurisdiction is vested, and such issue which only a DRT can decide cannot be a subject matter in a civil court. So though the Act says a banking institution or a financial institution can go before the tribunal for recovery, take a case of a borrower who has a dispute. If such dispute can also be a part of adjudication in the dispute which the bank seeks to raise, then you are not entitled to go before a civil court. How do we find an example to this? Suppose I have a dispute on a statement of account. I have a dispute saying that certain amounts which I have paid is not being shown in credit. I have a dispute on the outstanding which the bank claims from me, for which I can go before a civil court and ask for a declaration. But in terms of RDB Act, what it says that claim on a calculation or that claim on a statement of account can only be raised when the bank comes before the DRT for recovery of money. So therefore, when they file, you are entitled to defend it saying that this is wrong. Since the DRT has jurisdiction to decide that, the bar is on the civil court to entertain any suit. So a civil court cannot entertain a suit in respect of a banking dispute. I am just putting it in simple terms. It may not be the exact words. So if that is the case, now you come back to Commercial Courts Act. Now this act come into place. I will take you through the what it actually means a commercial dispute. Now when I take you through that commercial dispute, you will find that one of the limb of the definition says a disputes on banking transaction will be a commercial dispute. So therefore, under this act, showing it as a commercial dispute, I can maintain a suit. So a conflict arises. If it is a regular civil court, you are not entitled to maintain. There is a bar. But if I come under Commercial Courts Act, I am entitled to maintain. To address this issue, Section 10 says, notwithstanding anything contained in this act, still, if the civil court jurisdiction is barred, either expressly or impliedly, under any other law for the time being in force, that suit cannot be maintained. So a commercial court or a commercial division shall not entertain is effectively what it is there provided in section 11. So therefore, this is on chapter 2. So having seen the enactment providing for constitution of this commercial courts and commercial divisions and the hierarchy and the vesting of jurisdiction, as well as a bar which it has provided for. Now, having seen this, what would be essential for us to is understand what is this commercial dispute, what they actually mean to create a jurisdiction. And when I said about commercial dispute, I already pointed out, it also has another limb of called specified value. Now, this commercial dispute, to bring in within the ambit of this enactment, the Act provides in the nature of a definition under section 2. As I told at the earlier instance, any enactment has a preliminary chapter. So chapter 1 is there in the Commercial Codes Act. Section 1, I said short title, extent and common. Now section 2 is on definitions. Now the section 2, by subsection 1, it seeks to provide definitions of certain terminologies which are of relevance to this enactment. Now, having provided definitions of certain terminology, what subsection 2 of this section 2 does is that it says the words and expressions used and not defined in this act, but defined in the CPC and Evidence Act shall have the same meaning. So in effect, what the enactment has done is that it provided certain definitions. And if it is not provided for any specific terminology, it says you go to the definitions as provided under CPC and Evidence Act. So within these definitions, this essential feature of this enactment or essential feature in respect of vesting of jurisdiction of this enactment comes under section 2(1)(c). I think you'll be able to see in the screen now. So this is the definition which is of very many importance as far as the implications of this act is concerned. Now, commercial dispute means a dispute arising out of. It goes on giving a big list. Now you can find it says about ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. This is the common section which is being made use of because it covers merchants, bankers, financiers, and traders. So most of the disputes as far as Commercial Codes Acts are concerned, either it comes out by way of transactions which the merchants, traders enter into, and otherwise the bankers and financiers, which I said they have again a separate enactment. So whatever which doesn't fall there maybe is the consideration which comes here. Then mercantile documents. So effectively then you can find this is almost a case where you had the summary suits under Order 37 of the CPC. That was the preclude to this enactment. Even under CPC, you had a special area as regarding certain commercial disputes, which the courts seek to have a speedy disposal in a summary manner. So Order 37 provided for that. You can find identical words which are being found there. So this is one. Then it says export and import of merchandise and services. So all export and import transactions, whatever be it is, of merchandise or services, either you render services or you purchase goods or you sell goods. All those things, if it involves export and import, such suits shall come as a commercial dispute and therefore before the under the Commercial Codes Act. Then issues relating to admiralty and maritime law. Then transactions relating to aircraft, aircraft engines, aircraft equipment, so on and so. Then carriage of goods. Then construction and infrastructure contracts, including tenders. So agreement relating to immovable property. When they said agreement relating to immovable property, they used the word used exclusively in trade and commerce. So therefore, today, if there is a suit for specific performance of an immovable property, which is a commercial property, which is used in the trade or commerce, then that suit becomes a suit which has a commercial dispute and therefore before the commercial court. Suppose if there is a specific performance suit of an immovable property which relates to a residential property, then it doesn't fall. Therefore, agreements relating to immovable property used exclusively in trade and commerce. Then franchising agreements, then distribution and licensing agreements. Now, these distribution and licensing agreements you can find enormously in this media matters like movies distribution licensing, or now you have this web movies, whatever media you take, social media, including social media, all those things. So if there is any disputes on the distribution and licensing in respect of this, it will come. Then management and consultancy agreements, likewise joint venture agreements, shareholders agreements, subscription and investment agreements pertaining to services, including services industry, including outsourcing in financial services, mercantile agency and mercantile usage. Now, like your agency agreements where distributors, agents, stockists of all mercantile, which is done. Then partnership agreements, then technology development agreements, then intellectual property rights. This takes care of all intellectual property rights like trademarks, copyright, patent, design. So any suit which relates to any of these IP rights, it is today a commercial dispute and therefore comes within the purview of the Commercial Courts Act. Then agreements for sale of goods or provision of services. Then exploitation of oil and natural gas. Then insurance and reinsurance, contract of agency relating to any of the above. Now under the subsection 21, you find contract of agency relating to any of the above. So up to 20, whatever you have seen, relating to any of those things, if there is a contract of agency, if there is somebody who is appointed as an agent to carry out, if there is somebody who is appointed an agent to perform certain duties, then any dispute arising thereto is again a commercial dispute. Then such other commercial disputes as may be notified by central government. So there is also a provision with regard to notification which central government can bring about, including certain commercial disputes. Then interestingly, there is one explanation to this. Explanation says, a commercial dispute shall not cease to be a commercial dispute merely because then two limbs. One, it involves action for recovery of immovable property or for realization of monies out of immovable property given as security or involves any other. So therefore, if a suit involves only recovery of money, by virtue of that, it doesn't cease to be a commercial dispute. How you look at it, if it is for recovery of immovable property, and if such immovable property is a commercial property, as I said in the earlier portion where they said agreements relating to immovable property used exclusively in trade and commerce. So therefore, if you are able to bring about, and still if the suit is only for recovery of immovable property, it is a dispute to be reckoned within the commercial dispute. And likewise, if there is realization of monies. For example, if there is an agreement for sale and some breach has happened and therefore you want to now go for a suit to recover the advance amount, whatever you have paid under the agreement. So it relates to a recovery of monies out of immovable property given as security or so on so. So even if this is the case, it doesn't cease to be a commercial dispute if it satisfies any of the above things which you have said. Then interestingly, B, it says one of the contracting parties is the state or any of its agencies or instrumentalities or a private body carrying out public functions. So in a contract, if there is a state, as we have seen so many things, for example, a sale of goods, a contract by a state or a state agency. You have state marketing agencies which are doing huge businesses. So a part of that, if you have a contract for sale and there is a dispute, still it will be a commercial dispute and the suit will lie as a within the purview of the Commercial Courts Act before a commercial court. So therefore, merely because that the contracting party is a state, you cannot take out of it. It uses a word shall not cease to be a commercial dispute, and any of its agencies, instrumentalities, which you are all aware. So this is one area. One area of importance, as I said, is that you need to identify what is a commercial dispute. Now, what is the implications? So if a particular suit has to be brought within the ambit of the Commercial Courts Act, then as part of your pleadings, you have to satisfy the court that there is a commercial dispute. Then you have to explain in terms of the definition under section 2(1)(c) and further subsection and say that this falls within this category. So therefore, there is a requirement of an establishment of fact as to existence of commercial dispute. Likewise, in pending suits, which the Act also provides that there can be transfer of these suits, in pending suits also there is a requirement of the court to determine whether there is a commercial dispute involved. So once this determination happens, the jurisdiction starts vesting in terms of the other provision, and therefore it goes on. So this is one area of it. Now, having said this, now what we have to see is that I also pointed out there is something called specified value. Now, please see the definition under 2(1)(i), CI. It speaks about specified value. In relation to a commercial dispute, shall mean the value of the subject matter in respect of a suit as determined in accordance with section 12, which shall not be less than 3 lakhs in rupees or such higher value as may be notified by the central government. So the Act provides that even in respect of a commercial dispute, to bring it within the Commercial Courts Act, the said dispute should be of a specified value. And in terms of definition, this specified value as on date is 3 lakh rupees. So if there is going to be a question to you as to how do you arrive at this specified value, this definition itself says that such determination shall be in accordance with section 12 of the Act. So at the first instance, the Act provides for a specified value. So you need to satisfy the court that I am falling within the specified value. At the second instance, then how do you look at what is the specified value? That is, in terms of this definition, you will say 3 lakhs or it should not be less than 3 lakhs. So therefore, 3 lakhs or above. Then the third aspect is that determination. Suppose in a suit, there is no recovery of money, but there is some other dispute and some other remedy. A remedy may be a mandatory injunction, a permanent injunction, or declaratory relief. So in that case, how do you determine this? That is provided under section 12. So this is the second area of it. Now it also says as may be notified by central government. So in this context, one small nicety which is involved is that as you see from the provision itself, which is within the brackets, it is shown which shall not be less than 3 rupees. And this bracket enumerates that this was substituted by Act 28 of 2018. So therefore, what had happened is that prior to this, in terms of the original enactment in 2015, the specified value was 1 crore rupees. Now the provision, the last limb of the provision says that 1 crore rupees or such a higher value as may be notified by the central government. So what was provided is that in the original enactment, the intention of the legislature is that we will have only suits which cover 1 crore and above or any higher amount. The court may decide. Now, after a period of time, it dawned upon the legislature that there is a requirement to bring down the specified value so that more number of suits are coming within the ambit of this enactment. Therefore, this 1 crore was sought to be brought down. Now, in terms of the section, they could have given a notification only if it is more than 1 crore or higher value. Now, therefore, an amendment in 2018, which made it 3 lakhs. Now, in terms of the present amended provision, what is important is that now today, if the government wants to have this value fixed at 5 lakhs or 10 lakhs, there is no requirement of further amendment to this. What they can do is that notify, just publish a notification. Once the notification is made, then the pecuniary value will automatically change in terms of the notification. This is just for an academic interest, which I am trying to bring across to you. So having said this, now on the specified value, what is that which we have to further require to see is that section 12. I said the provision said determination of specified value. Please see what is section 12, determination of specified value. The specified value of the subject matter of commercial dispute in a suit, appeal, or application shall be determined in the following manner. So then they put across certain things. They say that if it is for recovery of money, then the money sought to be recovered in a suit. This is the first instance, okay, including interest, whatever it is computed. So it is a simple situation. Then if it says second situation is relief sought in a suit relates to movable property or a right to movable property, then market value of the movable property as on the date of filing, appeal, so on so shall be taken into consideration. So this second limb is a valuation which you have to arrive in respect of a right relating to movable property, which is market value of the movable property as on the date of filing. Then third limb says if the suit relates to an immovable property and a right therein, again it is the market value of the immovable property as on the date of filing of the suit. Now fourth is a relief sought in a suit, appeal, or application relates to any intangible right, the market value of said rights as estimated by the plaintiff. As a students of law, what is important is that these words as estimated by the plaintiff. Now, interestingly, this as estimated by the plaintiff is not there in A, B, or C. A says if it is a suit for recovery of money, amount with interest as on the date of filing, as computed. Then B says if it is related to immovable property and right, market value of the movable property. Therefore, a defendant can also raise an issue. You can bring about a market value. Then third again, market value of movable property. But if it is a case of intangible rights, the market value of said rights as estimated by the plaintiff. So this is the slight difference which you can find for a purpose of the understanding. Then it also speaks under subsection 2, the aggregate value, which as civil suits we normally arrive at if there are multiple reliefs, you make out an aggregate value. So that is provided. Then interesting is subsection 3, which says no appeal or civil revision application under section 115 of the Code of CPC, as the case may be, shall lie from an order of the commercial division or commercial court finding that it has jurisdiction to hear a commercial dispute. You will recollect at the first instance I pointed out section 8, which said there shall be a bar as against orders in applications, where I have explained to you revision will not lie. Now, interestingly, in 12, as regarding determination of specified value, they provided a specific subsection. This is probably because this issue is a jurisdictional issue. Normally, whenever there is a jurisdictional issue, High Court also has a tendency to interfere and has a right. Every person can canvass saying that if there is a jurisdictional issue and if the jurisdiction goes to the root of the matter, therefore you have to interfere and make it clear that the court does not have jurisdiction. But interestingly, in section 12, subsection 3, they say that even if a jurisdictional issue is decided, then no appeal or a civil revision shall lie under 115. So therefore, you have to fall back to your other appeal remedy, which is provided under the enactment. So this is on the second limb of it, which we have seen first at the constitution and the jurisdiction, second on the aspect of the commercial dispute, a definition to the commercial dispute. Then you have seen the specified value which is provided. Then thirdly, we can look at what is the other provisions which are provided. One important provision which we have to take note of is what kind of appeal which it provides for. Section 13 provides for the appeal remedy. Now, when it speaks about this appeal remedy, we have seen the hierarchy. So in terms of the hierarchy, if there is a judgment of a commercial court at the level lesser than the district court, it will go to the commercial appellate court. Then if there is a judgment or decree of a commercial court at the level of a district court, it goes to the commercial appellate division of the High Court. Similarly, if there is an appeal at the commercial division, it goes to the commercial appellate division. So these appeal remedies are provided under section 13. Section 13 also makes out clearly as to the time limit within which these appeals are to be provided, which is 60 days. Then there is a provision which speaks about procedure of CPC as amended being made applicable in terms of the appeals, as well as section 37 of arbitration conciliation. Then it also provides, more importantly, under subsection 2 of this section 13, which you can find in the screen, again, a non-obstantee clause. Subsection 2 of section 13, which says, notwithstanding anything contained in any other law for the time being in force or letters patent of a High Court, no appeal shall lie from any order or decree of a commercial division or a commercial court otherwise than in accordance with the provisions of this Act. So, likewise of other provisions, one enabling provision as to the vesting of jurisdiction in filing of appeals, likewise a barring provision which also says that other than what is provided under this Act, you cannot have any other appeal. Then section 14 speaks about expeditious disposal of appeals. Then 15 provides for, under chapter 5, transfer of pending cases, which provides that whatever pending suits, those proceedings, if it is having a commercial dispute, it has to be transferred. That is where I said a requirement of a determination is required in terms of section 2(1)(c) as to the existence of commercial dispute of a specified value. So once this is decided, then the provision also enables as to at what stage it will continue, at what will happen to the procedures. It protects to some extent, saying that whatever has crossed the stages, it will not have an effect. From the stage where it transferred, it has to take care of itself. So this is on section 15. Now, having said this, what is important at the closure of this issue is that we have seen chapter 1, which is preliminary, chapter 2, which is on the constitution, chapter 3, section 12 is on the determination, specified value. Then I have said to you about appeals, then transfer of proceedings. So with this, what is left is only two important areas. One is chapter 6, which speaks about amendments to the provisions of Code of Civil Procedure, which is under section 16. This chapter 6 has only one section, which makes an amendment to the Code of Civil Procedure, and whatever amendments which are made and which has an application to the commercial disputes before the Commercial Courts Act is given in the schedule. As I said, schedule is an exhaustive provision as far as the CPC's provisions has made applicable to the Commercial Courts Act. Now, with this, what is left is finally is that section 12 capital A, which is pre-institution mediation and settlement. This was brought about by way of the 2018 amendment, which provided this section 12 capital A as to pre-institution mediation. Now, in this section, what the Act effectively says is that one exception is given. It says, which does not contemplate any urgent interim relief under this Act. So, for a moment, you forget that exception. If you forget, what it says is that a suit shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. Then it provides the central government may by notification authorize the authorities constituted under the legal service authority so and so. Then notwithstanding anything contained legal services authorities as may be authorized by central government shall complete the process of mediation within 3 months. So what is required is that before filing a commercial suit, or rather if you have a dispute to be raised before a commercial court arising out of commercial dispute, it is now mandatory that you have to exhaust this pre-institution mediation in terms of 12A. And this pre-institution mediation, there is a time limit which is specified that shall be done within 3 months. Now, this can be further extended for another 2 months. Now, what is the only exception is that a suit which does not contemplate any urgent interim relief shall not be instituted. So, therefore, if a suit contemplates an immediate urgent relief, suppose if you are filing a suit which requires an immediate interim orders which has to be sought for, which you require some person to prevent or which require some protection to be taken or protecting the relief which you are seeking. In those cases, you can bypass this section 12 capital A pre-institution mediation and you can file a suit. So this is brought about by way of amendment in 2018 by bringing chapter 3A.